It is only in these questions. When he is investigating this, when he is investigating a psychotropic substance case, if the director or other authority specified in subsection 1 is of opinion on the basis of information or material in its possession, that the provisions of any other law, that is, other than the psychotropic substances, other than Mulad's illicit traffic, other than foreign exchange, please appreciate it has nothing to do with two. And it's settled law. Your Lordship, I'll show that. That's the case. I'll show to your Lordship any number of judgments. So if he's investigating a case under tax, or he's investigating a case for duty or cess, or dealing in foreign exchange, and he finds that some other offense has been committed, he has to go to the state machinery. That's the law, mothers. They are here in, I hope, mothers, I'm making my point. They are here investigating what? Proceeds of crime in respect to what? Oath scam, for which an FIR is registered. In the course of that investigation, they find that some other offense has been committed. Under 66(2), they have to refer it to the state. Right? And what are those other offenses? Just see the petition.
You want that if the CM barges in and CM commits any offense, the ED will inform the state government, which is headed by the CM.
CM.
If the chief minister barges in, commits an offense, obstructs the ED what is required to do according to your submission is that ED will inform the state government whose chief minister has barged in. That is your argument. We have understood. We have understood your argument.
Lordships are getting upset for no reason.
No, I am not.
Let me explain.
We are just trying to explain you that we have understood it.
No, your Lordships haven't. Because your Lordships are now saying that you're assuming that the CM has committed offences.
No, we have not.
You are, Mother.
That is the fact.
Well, how is it the fact? It's an allegation.
That is allegation.
So don't say it's a fact, Mother.
Yes, you are right.
That's all I'm saying, Mother. There's nothing more. Once your Lordship
these are the
once or twice.
Don't mistake us, Mr. Simple.
It's an allegation.
Allegation on us?
No, it's an allegation by them against the Chief Minister.
Yes, that is the allegation.
And
that is
which is published every
because of that allegations are here, all of us are.
Honorable Chief Minister comes on the media and says that yes, I have collected every evidence which is gathered by the
It is not a fact, is what I'm saying. It's an allegation.
Yes, it's an allegation.
So you can't assume that
allegation is always based on some facts. If there are no facts, there is no allegation.
That is to be investigated.
There has to be some factual foundation for every allegation.
That is to be investigated.
Yes, and that is what they are praying for.
For CBI to investigate.
Whatever agency.
No,
that is their prayer.
The point I'm making is 66(2) doesn't allow them to do that.
Yes, please. We are just trying to apprise you what we have gathered from your argument.
No. Whatever I'm trying to interpret 66(2).
No. You are trying to say that when any offense is committed,
yes,
while investigating if the PMLA investigation is underway and some other offense is come to the notice of the ED officers,
right,
then the concerned agency,
yes,
in this case,
yes,
state government,
yes,
should be informed.
Yes. Now, let me explain. Forget
yes,
the CM for a minute. We're interpreting.
No, we have not. I have not said again CM. Since you are accusing that the moment we say CM,
no,
we are assuming something.
Right. I'm just.
Second time I have not mentioned.
No, I'm not saying this, Mother. Not yes, assuming, Mother, an ordinary yes, person, an investigation is taking place, Mother, and somebody finds that an offence under the IPC has been committed by an ordinary person. 66(2) will apply. 66(2) will apply.
Yes, you argue.
That's the point I'm making, Mother.
Yes, please.
Forget about authorities. At the moment, I'm saying 66(2) provides provides a provision under the PMLA that if number 1 applies, that is subsection 1 applies, and during the course of investigation, right, an offence is committed, then it must go to the state agency. Now there is a case, Mother, which has come to this court in respect of a Deputy Chief Minister of Karnataka, where during the course of a tax rate, Mother, it was found that certain other offences have been committed. Right, Mother? That was referred to the state agency. That was objected to.
Yes.
think my lord is also aware of that.
No, we are not aware.
My lord is aware. My lord is aware because he
Here
was,
the questions are on a far larger scale in this petition. You are arguing 662 all right, but the questions here involved are on far larger.
I am not disputing that at all.
The allegations are true, then it's directly strikes at the rule of law.
No.
It is Article 14.
One second,
That is the article.
1 second, yes, we'll come to
This
that.
is what,
Well, that's, at the moment, what was I interpreting? 66.2? I was not talking about this, Mullah. I was interpreting, my lord said 62 it doesn't apply.
these questions are important, you may be right.
Yeah.
Then the questions.
That's right, I'll answer that, Mullah.
Here very on a large.
I'll answer that, but at the moment I was only answering one small question. Your lordship said 66.2 doesn't apply. Your lordship said it doesn't. I was only answering that, Mullah. I was only answering that question, that 66.2 apply. Your lordships put to me another question altogether. You are saying even if 66.2 were to apply, this has a much larger ramification. It's what my lord is putting to me. I understand that.
By very nature of the controversy raised in the 32 petition.
Yeah.
It is a very higher petition.
I agree, Mullah. I am not disputing that. I was at the moment, Mullah, talking.
Every aspect to be seen in that.
That's correct. I will answer that, Mullah. I will answer that. I was just answering
And
this.
why 66 may not apply is, we are asking the question,
Sure.
not that we are assuming something.
Yes, sir.
If you don't ask any question,
No, please do.
keep quiet,
Yes, no, Mullah. How?
and then deliver a
When
judgment,
I answer, Mullah.
then you will,
Difficult.
anybody,
True, true.
it's difficult.
Please ask.
What we have understood that, you see, there are two distinct allegations.
Right.
PMLA allegations at the first place,
Right.
which ED is inquiring.
Right.
That is one set of allegations and one set of offenses.
Correct.
And this particular allegation
Yeah.
is a separate set of offense.
Right.
This offense, the second set, which the petitioners herein are alleging, that has not been committed in continuation of or while the investigation of PMLA offense was undergoing.
Yes.
There are two distinct offenses.
Right.
While PMLA offense is going on, PMLA officers have not unearthed or come across some other offense. It is an offense in which is committed by some other persons against PMLA investigators.
Your lordship is right. Your lordship,
Therefore,
what your lordship
it would
is
not
saying-
apply.
Yes, what your lordship is saying is that here the offences have been committed against those who were investigated. That's what my lord is saying, right, Mullah? We'll accept that prima facie to be correct, Mullah. We will accept that. Now, Mullah,
No,
let's
why
see.
shall you accept when we say
No,
there
prima
are,
facie. Since your
when
lordship.
we say it is fair, you object to it.
No, I'm not.
And now you are
Mullah, I'm
accepting that.
I'm taking the argument forward. Mullah.
Anyway, please proceed.
Mullah, if I don't take if you ask me question, I don't take the argument forward, the same thing will
That
happen.
exactly applies to
The
us.
same thing will happen, Mullah, if you don't ask the question. Now,
And we ask the question, don't
see the offences.
don't think that we are agitated.
Kindly see, Mullah. Kindly see.
And don't agitate us by saying that we are agitated.
I'm not agitating you.
No.
Kindly see section, page 38.
Yes. Page
38.
yes.
Abetment, criminal conspiracy, voluntarily causing hurt, wrongful restraint, wrongful confinement, force, criminal force, assault on or criminal force, obstructing public servant in discharge of public functions, omission to assist public servant when bound by law, disobedience to order during promulgated theft, theft in dwelling house, theft after preparation, robbery, dacoity, criminal trespass, house trespass, destruction, all that. These are the offences that are alleged to be committed by the officers of the state. That's the allegation, Mullah. Right?
Yes.
Now, Mullah, these offences have been committed. I'll assume, for the sake of argument, I'll assume. What is the fundamental right to move? If a person has been kidnapped, Mullah, so let's assume person is kidnapped. While he is kidnapped, he can move under 32. But if he has been released, he can't move under 32. in the light of what my lord put to me.
No, I was putting it in the context of 66, not in the context of 32.
66, brothers, even 66, even 66, these offences cannot be investigated by an authority outside the police station where they were investigated, as the code itself and the BNS. Any offence committed, brothers, within the situs of a particular area has under the law to be investigated by the police officer. That is brothers, settled law. It can't be investigated outside. It can be investigated outside only pursuant to a 226 petition. Or a transfer petition. What my lord was saying to me is absolutely right, that there's a larger issue. There's no doubt about it. But what I'm saying is entirely different for us. The law cannot change because there's a larger issue.
Now, yes, according to you, Article 32 would not apply merely because there is a larger issue. Article 32 petition is not maintainable merely because there is a larger issue. That is your submission.
I'm saying, Miller's 32 petition is otherwise not maintainable. I'm not on the facts at all, Miller's. I have indicated to your lordships how 32 is otherwise not maintainable. But 32 is also not maintainable on the simple ground that this offence, whatever it may be against A, B or C, will only be investigated in the area in which it has been committed by the officer in charge of a police station. That is under the BNS and under the old code, Miller's. That can't be per se in law investigated by third parties. That can be done through a court. The reason why I put forward this proposition is, if there is a statutory remedy, that statutory remedy has to be followed. That was the proposition. Yes. I'm not saying 32 can't, it is on the maintainability of 32. I'm not on the facts. It is a statutory remedy. That statutory remedy has to be followed. You can't invoke 32. The 32 article can't be invoked, Mothers. And that's...
Yes.
Right. So, Mothers, the point I'm making is, I am not, Mothers, at the moment I'm on the fundamental point, it's not maintainable. So the proposition is not, Mothers, on the allegations. Proposition is, there is a statutory remedy provided. That statutory remedy has to be followed. And once there's a statutory remedy...
Which is that statutory remedy according to you?
That wherever the offence is committed, that police station will have jurisdiction. That's it.
The statutory remedy is 156(3)?
Yes, it can be, yes, 156.
Under
First FIR.
Under Sakri Vasu?
First FIR.
FIR.
Then if it...
Or information to the SP.
Correct. Then under Sakri.
Then
yes.
156.
Then 156(3).
If not,
Mothers, then somebody, and he can say, he can direct FIR be registered. Right?
If not 200.
Then 200.
200 CRPC.
That's right. Otherwise, 226, 406.
Which is that offence to be investigated under 632?
Sorry?
Which is that offence?
These are offences.
To be investigated 632.
These are offences. These offences. BNS offences. BNS offences, Mother. These are offences under BNS, I hope, Mother. These are not offences under any other statute. These are BNS offences committed in West Bengal, in Calcutta. Now, as your lordship knows, BNS says offences will only be investigated by that police station.
Now, the tenor of your argument is to be the offence or the whole situation?
No, I'm not on situation, I'm on the offences. My argument is 32 doesn't, I hope I'm making, I am saying 32 doesn't lie. I'm not saying anything else.
All is without thinking.
Yes.
This is all from your
I know, I am.
without thinking.
32 doesn't lie is what I'm saying. If there is a statutory remedy available for a particular offence, 32 doesn't lie. That's all I'm saying. Right? Where does 226 lie?
That is fundamental principle.
Yes. And where does 32
whether
lie?
It is
226
whether
lie?
it is 226 or 32,
Yeah.
if there is a statutory alternative remedy available, these proceedings would not lie. That is the fundamental.
No, I'm not even, where the offense is committed, that police station has the jurisdiction to investigate that offense. Right, Malas? That offense can't per se be investigated by somebody else till there is a remedy, and that remedy is 226 by the person who is aggrieved. 226.
Correct.
And he can then allege that this can't be investigated here, as my lord put to me.
So you are saying that for statutory violation, 32 will not die unless it is a fundamental right.
Unless it's a
That
fundamental.
is what you are saying.
If it's a fundamental right, Malas,
You understand?
if it's a fundamental right,
Then only 32.
no, Malas, I don't think
Your
that.
fundamental.
No, I'm not saying that, Malas. Once there is a statutory remedy in respect of a criminal offense, Malas, I don't think I can make it clearer. There's a criminal offense committed within a particular area in a particular state. Then under the BNS, that investigation must be done in that state. Even if there's a violation of a fundamental right, it has to be done in that state, Malas.
Yes.
It has to be done in that state, even if there's a violation of a fundamental right.
Yes.
And there are remedies available. You can file a 226, Malas. But Malas, we are going beyond what
No,
I'm
but-
arguing.
but
I'm not arguing that.
This principle applies to 226 also.
Yes.
That if a statutory remedy is available, then 226 is not.
But in this case, the statutory remedy is the commission of an offense and an investigation.
Yes, we have
That's all I'm saying.
We have understood.
Right? And 226 will lie where you say it is not being investigated. If it is being investigated, 226 will not lie.
No, we throw petitions, 226 petition on this ground also, that go 156.3, invoke 156.3. Don't ask for a mandamus or registration of a FIR,
Right,
Sakiri Vasu.
right.
Yes.
No, I understand that, Maras, but I am not arguing that point at this point. I am only saying that at this stage, that fundamental right cannot be invoked unless there is an investigation and that investigation is not moving forward properly. Then only it will be invoked. You can't assume. Cannot assume facts. Maras, for example, Maras, can they say that the state police cannot investigate that offense, Maras,
Yes.
as far as our allegation is concerned, with the commission of offences by them? Therefore, I can also file a 32. Is that the case, Malas? The NCP, ECR,
Essays are always interesting.
this one in particular.
No, whichever case.
Kindly see.
Yes.
Let's kindly see third paragraph, third page.
Yes.
So well that. Article 32, this is NCPCR, Malas, moving the court under 32.
Is a vital provision, yes.
Yes? Article 32 is a vital provision of Part 3 of the Constitution, which deals with fundamental rights and is a fundamental right by itself. This court can issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari right, whichever may be appropriate for the enforcement of any right conferred by Part 3. Citizens are entitled to appropriate relief under the provisions of 32, whenever there is a violation of any fundamental right. No doubt, when there is a violation of the fundamental right, public interest litigation is also preferred by and on behalf of citizens by public spirited persons, which are also termed as social action litigation. However, we find it strange that a statutory body, such as the petitioner in the instant case, is invoking Article 32 of the Constitution for seeking the aforesaid relief. When Article 32 is meant for citizens to enforce their fundamental rights, the said article cannot be the basis to file a writ petition by statutory authorities against the state, union, territory for seeking directions in aid of discharging its functions under the statute. The said article also cannot be the basis for statutory bodies or authorities to seek enforcement of fundamental rights against private citizens. The same is incongruous and not in accordance with what is envisaged under the Constitution. Direct authority on the point. Even if it's a statutory authority. And in this case, Madam, that's not the case at all, according to us, as I have argued and Mr. Devanand argued. The Directorate of Estates is not a statutory authority. Now, let's kindly come
But
to.
please concentrate on the fundamental right of the officers of the ED with whom or qua whom the offence has been committed.
On that, I have made my.
Otherwise, you will miss the point, both.
You are right.
If
On
you
that-
only concentrate on ED and forget the second petition,
Correct,
which is preferred by the individual officers
right.
who are the victim of that offence,
That is problem.
you will be in difficulty, I'm telling you.
That's well as I know, I'm not arguing.
If you argue ED, and don't argue the individuals who are the petitioners in the other writ petition,
Right.
then
I was
probably
not-
you
that
may
is
miss the
argued-
point. That is what we are
That's
alerting
being
you.
argued by someone else, well as I'm not arguing.
Whosoever is arguing, we are telling you. Yes.
What is it said?
Now, whosoever is arguing, otherwise,
But in the first petition also, petitioner number 2 is the deputy director.
he was not there on the spot.
Personally,
That is what Mr. Sibbal has
he is
said.
an accused in the FIR registered by them. I'll show that.
He is an accused.
Yes.
No.
Then he is a better case because if he is not there according to Mr.
In
Sibbal,
both the
and
petition.
while he is sitting in Delhi and he is made an accused for something.
Accused in what?
Everyone involved in the
In
raid.
our case, which has been stayed, that's all right, Mullah. It's not in their case.
Lord, he was in Calcutta. He was the supervising officer. He was supervising this search. I'll
He was
come
not
to
on
that.
the spot. He was not on the spot. He doesn't have a fundamental right. Nobody interfered in his
What
activity.
Mr. Sibbal said that P2 Robin Bansal was not at the scene of occurrence.
Yes, he's not
It is
there.
not-
He says that I am filing this for the officers of
That's right, I
CBI,
know that.
including myself.
I have already told
Yes.
that to the court. You can't be filing a fundamental right petition for others.
Yes.
What is the basic principle? What have they said? Which person has been? Well, she will answer that because she is in that petition.
Yes, because
Because I'm not in that. What allegation? Because she will answer, because I'm not. She will take care of that. But let's kindly come now to, now, Malaz, as your lordship said, I told your lordships last time, obstruction of a public servant is an offence under 221 of the BNS. Right, Malaz?
yes,
So they have a remedy.
yes.
And that's their right, statutory right at best, Mullah. Because it's not a fundamental right. The point I'm making, Mullah, none of these are fundamental rights. A person performing a statutory duty, the violation, any obstruction in the performance of that duty is not a violation of a fundamental right. Mullah, for example, a police officer is discharging his function. Somebody obstructs him. He can't file a 32 petition. He also can't file a 226 petition. There will be a prosecution launched for us for violating his right to discharge his functions. So where is the question of 226 or 32 coming? Because there is a statutory remedy. Now, you can't say, no, we don't have to go through that statutory remedy. I can file a 32. Well, then every police officer will have a file a 32. A state police officer will file a 32 against them. Then what will happen? So you can't, Mullahs, interpret a law in the context of a particular fact situation. And then, Mullahs, open a Pandora's box, which will be inconsistent with the basic features of the Constitution as well as the basic features of criminal law. So, Maharaj, ultimately it boils down to this. A person performing his statutory duties, if he is interrupted in the performance of those duties, then per se there is a violation of a fundamental right.
Yes.
That's the proposition probably by the other side. That's a proposition which, with the greatest respect, cannot be accepted. because a person has no fundamental right to investigate. He has only a fundamental right, he has only a right under a statute to investigate. And a violation of that right is not a violation of his fundamental right.
Yes.
Right. Now kindly see his averments in ground ZZ mothers. Page 41.
Page?
41. Because false, frivolous and retaliatory FIRs were deliberately registered against ED officers, not on account of any unlawful conduct, but solely with the object of criminally intimidating them, browbeating the investigating agency and deterring the performance of statutory functions under PMLA, which is the teeth of Article 14 as well as Article 21. Where does Article 14 or 21 come in here, Manas? If the allegation is that they have committed offences, Manas, how does Article 14 and 21 come in? Guarantees free and fair investigation by investigating agencies. How does that 21 come in? Then let's kindly see grounds AA at page 27.
Page 27.
27, ground AA. Because the search and seizure operations conducted by officers of the Enforcement Directorate were lawfully authorized under 17, pursuant to reasons to believe. Right, Malas? So therefore, that they are exercising their statutory right. Now kindly come to DD, page 28. Because the acts of wrongful restraint and confinement of ED officers, possible removal of digital devices, disruption and intimidation during such collectively amount to frustration of statutory powers. They are not talking of fundamental rights. It is their own case, Malas, that they were exercising their statutory powers which are frustrated. Which is that fundamental right that is violated? That's why 221 of BNS. Then GG at the bottom of 28, because section 67 of PMLA, protection of action taken in good faith, provides that no suit, prosecution, or other legal proceeding shall lie against any officer for anything done or intended to be done in good faith. Because the ED officers were acting strictly in discharge of statutory duties. There it is. Then page 43. It is their own case, Malas. Triple L, Malas, at page 43.
Yes.
For that, the facts disclose direct involvement of highest political executive, abuse of police power, theft and manipulation. That this honorable court has consistently held that where high and mighty states are involved in commission of cognizable offences, investigation ought to be transferred to CBI. This is now, they are going beyond Muller's, the fundamental rights issue. So Muller, the petition, the argument before your lordships is, it is their own case that in the discharge of their statutory duties, certain offences under the BNS were committed. Others, that is not the basis of a fundamental right, can't be that. And the PMLA itself demonstrates that powers flow from the statute, not any provision of the Constitution. Powers don't flow from 21, don't flow from 14, don't flow from 19. They flow from the statute itself, whether it's the CBI or it's NDPS or any other statute, they flow from the statute. A violation of the statutory exercise of power is not a violation of a fundamental right. As a matter of law, it can't be. Now, I read to your lordships the other day and I don't want to repeat it, Just to show, 49 your lordships will remember, 48 and 49 of PMLA.
Yes.
So that we are clear on, what the submission.
48 and 49.
48 and 49.
Yes.
49 says, the central government may appoint such officers as it thinks fit to be authorities for the purposes of this act. Right, and there shall be the following classes of authorities. So the authorities are appointed by the central government. That goes to the first proposition that I addressed your lordships on.
Yes, yes.
Having been appointed by the central government, the Directorate of Estates can't have a fundamental right. The aggrieved party is the central government. And the central government can't file a 32 petition, as I mentioned to your lordships. Nor can the central government file a 226. The individual certainly can file whatever he wants to file, but that individual can only go under BNS 221 because he's being obstructed. He has no fundamental right. And he is claiming it as an officer of the ED, not in any other capacity. I can understand if he claimed it as an individual, but not in any other capacity. Because he is saying, even in the other petition, it's the same. He's only claiming it as an officer of ED. So where is the question of a fundamental right here? Because the moment your lordships were to even lay down that law, then every officer in discharge of his, whether it may be customs, it may be any officer, the moment he is obstructed, it is a violation of his fundamental right. That, with respect, would not be a proper enunciation of the law. Then, now let's kindly see, very interesting here. But before I go to that, a more fundamental issue. When is a fundamental right, when can a fundamental right be invoked? Basic principles. When it is being violated. A fundamental right cannot be invoked when the alleged offense is already committed. As a matter of law.
Yes.
I am forcibly kidnapped by somebody. My wife goes to court and says, look, I want to file a petition. My husband has been kidnapped by somebody. It's fundamental, and he continues to be kidnapped. Petition will lie. But if he is kidnapped and he is released, and then she invokes Article 226 or 32, petition won't lie. In Sonam Wangchu, for example, he was released. It was dismissed as infructuous. Why? Because the fundamental right doesn't inure to his benefit anymore. So all these allegations are made with what happened in the past. So how do you invoke a fundamental right? In respect of incidents that have taken place. You can only invoke your powers that, look, an offense has been committed, and therefore proceed in the matter under 221. There is no existing fundamental right today at the time when the petition is filed. This is a fundamental issue that your lordships will have to decide.
For that only we are hearing.
No, I'm making the propositions.
Yes, yes.
Of course, fundamentally, this is where the proposition that I'm
We
addressing.
understand.
logic on.
Yes.
It has to be an existing fundamental.
Yes, it should be a continuing violation of a fundamental.
That's right,
right.
then only it will be invoked.
So that we invoke or issue the writ.
Exactly.
Continue.
My lords, may I mention item 16, interim order may be extended.
Item
16, interim order.
16.
Sorry, Millers, item 25 is the Delhi matter Millers edition. So cost of 51 hospitals Millers was returnable today. May not be taken up possibly today. Millers may give another date Millers. Item
We'll see at the end of.
very well.